Hello, everybody. Welcome to Winning Strategies for Sport Visas. So today we're going to look at sports visas for athletes, sports visas for sports organization, coaches, essential staff, and we're going to cover just the general principles requiring us to do that. So let's launch right into it. Just a little introduction. I'm Cliff Rosenthal. I'm a partner at WI Immigration. With me is my esteemed colleague, Josune Aguirre Gamez, who will be sharing this platform with me. And we hope to give you the information you need so that you can make the critical decisions that you need to do in order to get to winning ways in the sports arena. Legal disclaimer, we are lawyers, we have to do legal disclaimers. Anything you hear today is not going to be considered specific legal advice for your specific situation. The real purpose of this is to give you enough information to ask the right questions so that you can get in touch with a reputable legal representative. It could be us, it could be somebody else, but just like you wouldn't do surgery at home, and the recommendation is not to do legal surgery in this arena as well. So the information you'll hear will be informative, and this is the purpose of this webinar.
Right. And here at WI Immigration, our mission is to collaborate with y'all. And so our logo, Journeying Forward, is so that we can truly partner with you, not only with our technology and our legal services, but inclusive collaboration as well. And we always have to do a little boast where we are award-winning. We have 9 offices globally, and we do put our values not only in our firm, but also with our clients and our work.
Just a brief agenda of what we plan to do today over the next half an hour. We're going to look at the different types of sport visas, which is the most appropriate, and we'll see some different types, mainly the O1, the P1, and the B visas. So we're going to look at those. We're going to look at how that affects athletes, what they can come for, and also how support personnel, essential team, what they can do. That might be a little bit different. The type of visas covered we mentioned, and then we're going to end up with what's called NIL, name, image, likeness, which is a very topical part of the sports visa arena at the moment. So since the Supreme Court held that student athletes need to be compensated then for the use of their name, their likeness, and their image, how does this affect student athletes who usually don't have work visas? So that's what we're going to see about as well. So Josune, why don't you let us launch into the P1 visa. The P1 is what I would call your standard athlete visa. So tell us a little bit about that.
Yeah, definitely. So when we're looking at P1s, we do have the definition that it's a high level of achievement in the field. And I think sometimes that can be intimidating, but it's important to note that it's not the same level as an O1, right? We're not having this high level go and exceed our usual understanding of scrutiny when it comes to O1, but we do have to show recognition in the field, and we're looking at different types of evidence, but it is very specific to coming to the US to perform a specific athletic competition at an internationally recognized level.
So Josune, tell us a little bit more about that. It has to be a competition.
It does. It has to be a competition or a sporting event. The P1 validity, we have a max of 5 years, but we do find that organizations find it better to maybe request 2 or 3 years because we're requesting an event that can just be the contract between the athlete and the organization, for example. But it is limiting. So it's not to do promotion. It's not to do training. It is to perform a specific athletic competition or event.
So whatever somebody just wants to live here, train here, do some promotions, and all their competition work is in a European league.
That's great. We're going to go into different types of visas, including the one, like you said, and sometimes the visitor visa. But when it's here to just live and do that, the P1 is not the most appropriate one for that type of activity in the US. So for strategies, when we're going into that, Cliff, you can tell us a little bit about what we found that helps us in creating a successful P1 petition.
Okay, so just looking at the P1, we're really looking for a claim. And a claim and its international recognition is really the same type of, it's synonymous with each other. So for athletes, you usually have your standard ones. You're looking at awards. You're looking at press about the person. You're looking at rankings about the person. Does the person have an international ranking? But it's not meeting these on a standard level. It's really showing how each ranking, for instance, if you have a ranking of 1,000 and there are only 1,500 athletes in this particular sport, then that doesn't really show international claim. So depending on the sport, depending on how wide-ranging that sport is and how big the sport is, you can adjudicate that appropriately. For instance, if you have a ranking of 100 and they're, 1,000 or billion people doing the sports. And obviously that's going to be very, very probative. Press, they're looking at what type of press. Is it, some sort of blog, or is it really something that people read? Especially in today's age, there are a lot of non-standard sports or sports that really use social media. So if the social media is very, very probative, a blog that is very, very well recognized and it has a lot of hits, for instance, even YouTube that has a lot of hits, this could be very, very important.
So we got a question if we can give a sample of a good P1. And so I think you hit on a lot of those, where we're looking for ranking, we're looking for press, even if that press is like a social media page or a blog, we do highlight those. And so for a standard P1, where we look at it and we think, this is going to be successful, is a clear contract, a great promoter, great rankings, great press.
I think if you could summarize it, I kind of look at three things. I think the first thing is petitioner. You have to have a petitioner that's either going to be an agent, a sports organization, or it's going to be some sort of team that's going to be the petitioner. Number two, you need a contract. You have to show what you're doing in the United States. In other words, they're not going to give you a visa so that, as we said, you can hang around and train. You're going to have to show the competitions that you are going to do. So for instance, if you have a competition for, a series of competitions over 5 years, which is the maximum of the P1, then that can be easier to show. But if you don't know what you're going to do, that's more difficult. That can limit your visas. A contract of what you're going to do is critical. And then the third part is what I'd mentioned earlier, is the claim. So those are kind of the three essential elements.
And something to note with the sports visas is that we do see a lot of written summaries of oral agreements. Now, that does probably seem strange, but it is quite common in the sports area. So that's something that you can also include. Now, for our O1, we need to demonstrate extraordinary ability. So as I mentioned with the P1, we did have a high level, but here we're looking at extraordinary ability. So that's a bit of a higher level.
Yeah, so definitely. So that's kind of the main difference between the O1 and the P1. The O1, you have to show you one of the very top in the field. You are one of the percentage at the very top, and that's very, very high. And that's very different from the P1, which is what we said was international acclaim. So international acclaim, you don't have to be at the very, very, very top, but you do have to show something that you are recognized in the field. Legally and practically is a vast difference, because at the very top, you would have to show you're competing at the very, very highest level. And international acclaim is synonymous with somewhat lower level. Although you cannot obviously show the lowest level, you have to show some international acclaim.
Right. And when we're looking at some of the criteria, we're looking at awards. Common is press, membership, judging, remuneration. We're also looking at kind of the key benefits, and it's not so limiting, right, Cliff? So although it's a higher standard, a lot of times we are in a better position because we're looking to go beyond just that sporting event or competition.
Correct. So I think that is definitely key, and probably the most important difference between the O1 and the P1, why some people would choose the O1 over the P1 is really the limitation of the competition, because certainly the P1 is a lower legal standard and the contract, provision is really the same. So that's kind of the key difference. I also want to kind of just launch into a little bit about coaches here. I think this is, very, very, very important, is that in the real world, perhaps is quite a seamless segue from going from an athlete to a coach. And in this regard, for instance, someone who's a top athlete, it's just normal that they would have the credentials for being a coach simply because they've been around the top coaches and they know what's involved. But immigration does make a differentiation between an internationally acclaimed coach or a coach with extraordinary ability and one that does not. So for many, many years, there was kind of a big differential between this. If you were an extraordinary athlete, you were not an extraordinary coach necessarily. So, for instance, if you spent your whole life won a gold medal at the Olympics, it would mean nothing, because to a coach application, if you're not a coach, and you could not show international acclaim as a coach, that you've coached major teams, etc. So immigration kind of in the last few years has split the difference. They said that you have to show some evidence that you are an internationally acclaimed coach as opposed to an athlete. So they do that now. But you can use some of the international acclaim that you achieved as an athlete to supplement that. So essentially, you won a gold medal at the Olympics, you come to a team and you're coaching the team, then at that point, that would be sufficient. That, you could add the two, the coaching and the coaching that you did at a high level with your athletic performance, and put them together for an application, even though the coaching itself wouldn't, under past regimes, necessarily be sufficient.
Yeah. And that's kind of a good segue when you're in that field to then, I know we're kind of skipping ahead, but looking at long-term as well, right? So going from the O1 and having kind of that mix of maybe coaching or that transition to then maybe going for that green card later.
Right. O1s and P1s are really kind of the visas that you would use when you're coming to perform as a professional athlete. Those are generally the main ones. You would come for the O1 or the P1. You had a team that was based in the United States, or you had an agent who primarily competing in the US. There are some visitor visas. We call them visitor visas, but really it's much broader than that. But they're visas for those athletes that primarily live abroad. And they're coming into the US for a very specific purpose, a very specific competition, and then they leave. They never abandon their home residence, and they come for very short periods. And generally, for the most part, they're just coming in to compete in the home. So the major B visa, which is the tourist/business visa that applies, is what's called professional athletes. And these are professional athletes that really come in just for prize money. In other words, there's no appearance money, but just for prize money. They come for a tournament and then they leave, they get the prize money and they leave. That is sufficient. If there is appearance money, that becomes more controversial, and it seems that would not be permitted. There are some other inclusions in the business visa for athletes, for foreign-based teams. That's similar to the professional athlete in the first bullet. Basically, someone who's based abroad and they compete for a foreign team, and they're coming into the United States for a match, a competition, a game, and then plan to leave. And part of an international league or event is part of it. And then, finally, you have an amateur. Somebody who's a pure amateur athlete is allowed to come to the United States on a B visa as well. This refers to the status of the person as an amateur, not to whether they are particularly earning money for this particular event. So if you have a professional athlete that couldn't get their visa done in time, and now they want to come to the United States, they don't want to miss the competition, and they say, okay, I'm going to forego my appearance money because then I'll be an amateur. That will not work, because that's essentially a professional who is, who's taking amateur status for this particular event, which is not permissible.
Now, I can tell y'all, Cliff and I had some fun last few months with CBP really cracking down on individuals coming in as visitors or trying to come in as visitors when CBP felt it was inappropriate, right? So we do want to warn that it could get a little tricky, right? And so to be very careful when it comes to using the visitor visa for these purposes.
Yeah, they track you, they track your entries, they track your exits. They're looking to see what you're coming to do and how you're coming to do it. They ask you the questions, and, especially those athletes that come into the United States with lots and lots of equipment, and, they're going to check, are you really an amateur? Are you professional? Are you coming for prize money? What are you really here to do? And as Josune mentioned, we've seen, especially in the last few months, a lot of, CBP, the customs folks, and immigration folks, when coming to the United States, are giving a lot of athletes, a lot of those involved in athletics and support staff, a lot of hard times, and refused many as well. So be very careful.
Exactly. They want to see contracts. They want to make sure it's just tournament prizes. They want to make sure you're actually part of a team. So, things to look at.
Yeah, I don't think you can just jump on the airplane as a tourist. They really are checking into these. It's almost like you have to do an application when you arrive. So you have to be really ready.
Yeah. All right. But speaking of, bringing in the team, sometimes we really need athletes to have their essential support staff. And when we're submitting those applications, we're looking to document either their critical, integral part in the role, in the sporting event, or in the team's role, or in the athlete's role, but also, if we can, documentation of prior working relationship to show that it's not as easy for a U.S. worker to come in and do that role. And so we also have to look at consultation agreements or applicable labor unions when we're submitting these applications, but also contracts or summary of the contracts between the team or the athlete. But, a lot of times we're able to get these individuals in. It's pretty straightforward, and it does help smooth the whole athlete's performance and also their time here. And when we're looking at these, the typical roles we're looking at are coaches, managers, trainers, translators. A lot of times we do need specific translators to come in. We've even done one for scouts before. So, it does create a wide range.
Yeah, I think what's important is to kind of look at what the position is and how the position is. And if you can document that this person has really worked with the athlete significantly, I think that's the key to the winning case. Sometimes, and this is very common, you'll see significant others, road shows.
Hairdressers.
It's not a catch-all. And sometimes, when people get into trouble is when they use this category as kind of a catch-all category for anybody that wants to come along with the athlete. So for instance, under American law, only spouses are currently eligible for the P4 visas, which allow spouses. So if you have a significant other, if they don't qualify for a tourist visa, they sometimes try to get into this. If you've got the whole team, all the entourage of some very famous celebrities, athletes want to bring in all their friends and family. This is not the category for this. And most of the time, when we see problems, it's based on this. That's most of the time. The other time we see a lot of issues as well is when people don't want to go through the application process for a P1S O2. It can be expensive, can be time consuming, and maybe someone was added on late in the game, so to speak. Excuse the pun. Josune, why wouldn't somebody on a tourist visa allowed to come to the United States to be the essential team of an athlete?
Yeah, because they will be doing active work, right? And they're not going to be meeting one of those exemptions in the B1, B2 category, right? We're not going to be an amateur. They're not going to be part of the team technically, right? And they're not going to be coming in just for prize money.
No, they're not an athlete.
Yeah, they're not an athlete. So, it gets difficult. And although a lot of people have been able to get away with it and know that that's kind of practical and easy to do, especially when they're late in the game, we are seeing CBP crackdown. So not to be scary or scare anyone, but just want to show that the current trends, right? And we are seeing that right now.
So kind of looking at the application process and tips to make this as smooth as possible. So the application process is a bifurcated process. There are two parts, two components, and that's talking about the P1s and the O1s and all the O2s and the P1S, etc. So the first part is a petition that has to be filed with the United States Immigration Service. So that's number one. You file an application, the Immigration Service is going to say, do they think this person qualifies for the potential visa? And just about everything we've spoken to up to now relates to that petition, showing the international claim that there's a petition, that there's a contract, what the person's going to do in the United States, et cetera. So once that's completed, then they go to the next step, which is an application at the U.S. Embassy or U.S. Consulate abroad. So some people kind of forget that there's the second part, or that second part can really take some time and some planning as well. So the truth is both parts need time and planning. And, that's kind of the key aspect to these applications, is to get ahead of the game, get the applications in early and not wait till a week before the tournament. And I think this is really, where the stakeholders are unique in an athlete's case. In a normal immigration case, just say professional visa, there's usually the immigration lawyer, there's the employer, and there's the employee. And it's much more simple. In an athlete case, there are many more stakeholders. In addition to the athlete, there's the athlete's essential team. There's usually an agent or some representative, normally more than one representative. There is a sports team that could be involved. And then there's usually a sports organization that could be the governing body of the applicant, depending on the sport and how the sport is structured. So getting everyone on board is not always difficult. For instance, you might be following up with the athlete, and the athlete might think that the agent is taking care of it, and the athlete doesn't know what's going on with the application. And the sports governing body have a particular competition that they can't change, and this person's headlining this competition. What does that mean, if this person gets stuck? So I think it's really key to get all the stakeholders involved and to be included, and, start early and plan early, because that's the key. Things happen at the end, and that becomes difficult. Then what you tend to do is these two steps, you tend to merge them into one. And once you're doing multiple steps at a time, then things can become tricky and mistakes can be made, etc. I think that's really the key.
A few things I wanted to add, Cliff, that's okay. Now that we have a different in filing location, right? Now we're filing in Texas. We're looking to see if there's any new trends coming out with that adjudication as well. So just being mindful of that. And I know we're going to go into timelines and waivers, but kind of like what you said, starting early, screening early, because sometimes the individual may need a waiver of admissibility, which can take 6 months, right?
Yeah. So what kind of activities require waivers?
So if the individual has a crime involving moral turpitude, which could mean, any type of assault or fraud, any misrepresentation, but we're also looking at any drug offense or substance abuse.
Yeah. So what we see sometimes with athletes, we see possession of controlled substance, steroids. Why don't you address that? Just, what kind of issues can that
Yeah, so at that point, we're going to have an inadmissibility finding, and we're going to have to go through a waiver process. With that, if we're getting the visa, the waiver process goes through Washington, D.C. So unlike before, during COVID times, we were able to expedite these at times. We're not seeing that so often. And so this is an adjudication to waive that inadmissibility. So basically a waiver for that individual to be able to enter and get that, 2 or 3 year admissibility. And each time they renew, they're going to have to renew that waiver as well.
Now, your athlete client tells you, well, but, I wasn't arrested. Does that mean I still need a waiver?
Yes, without an arrest or conviction, it may be difficult, but we have to, tell the truth and go forward with that. And so if there's a finding of an admissibility based on the admission of the individual, then it doesn't matter if there's an arrest or a conviction. The admission is sufficient to find the individual inadmissible.
All right. And sometimes, especially with very, high celebrity athletes, it's all over the press, it's all over the media. It's very hard to deny an application in that regard. So just beware. Okay, let's talk a little bit about coaches. We spoke about coaches. As we mentioned before, coaches can be a little bit more difficult unless the person is a stellar coach. Why don't you tell some of our success stories, Josune, about coaches?
Yeah, I think we scared y'all enough, and we want to give you the positive approach here as well. We've had some really great experiences with esports because U.S. immigration has confirmed that they will treat esports as regular sports. And when we were initially a little scared a few years ago to see how these petitions were going to go, we found that USCIS was, amenable to our arguments, and we have success in having esports coaches, esports performers, esports promoters, right?
Yes, I mean, essentially esports are just treated like regular sports. Maybe that might not be so intuitive to some, but that's certainly the way the U.S. Immigration Service does treat them.
Yeah.
And we've had a lot of success with that.
And then Cliff, you had, recent fun one that's not it's a traditional sport, but not traditionally played, right? And it's a league of its own, but that was not an issue.
Yeah. So, you have your major league sports, and then your minor league sports, and then you have a whole lot of, kind of new eclectic sports. I don't want to mention the names of any sports to give away, client confidentiality, but, it doesn't have to be one of the major sports. It can be a small sport. It can be an eclectic sport. It can be a non-well-known sport. And, if you're getting with a P1, unless it's a competition and it's distinguished, that's usually sufficient. O1 is even less, as we mentioned, O1 is even less restrictive. It doesn't have to be a competition or a distinguished competition if the person's one of the very top of their field.
Right. So a short overview, if these athletes are considering long-term, the most natural progression is the EB1A, where we have to demonstrate extraordinary ability. That is a high standard, but, it is a natural progression usually from, let's say, an O1 kind of gives us that good foundation, and we can potentially go from O1 to an EB1. But we do have the final merits. And so, again, we don't want to spend too much time on that, but that's something that we look at when we're looking at potential long-term.
Yeah, I think it's just very important to note that not every O1 turns into an EB1, even though if you look at the regulations, they're virtually exactly the same, and they should be really treated, exactly the same or almost exactly the same. But in practice, we see the green card version a much higher standard. So just, be aware of that. Not every O1 equals a green card, at least in the EB1A category.
And then what everybody wants to know, Cliff.
Okay. So in terms of the name, image, and likeness, NIL, as mentioned before, this all turned on a Supreme Court case that, was dealing with a non-immigration context completely. And that immigration context was the student athletes. Where the student athletes who compete for universities, for instance, and, the universities are making a lot of money from their T-shirts and from their promotions, etc., whether it was permissible that they were not compensated for their name, their image, and their likeness because they were required to be amateur by the amateur rules of college sports. So that's where it all came in. The Supreme Court came down and pretty much said that, when it comes to name, image, and likeness, NIL, then, students should be compensated for what they provide. But this has a very unique context when it comes to student visas and those international students that are on F1 student visas, because F1 student visas generally don't have work authorization that comes with this. So it becomes a very big question is, whether this is considered employment that requires work authorization or not. And that's the first point. So for instance, if somebody is on the field, someone takes a picture of the back of their shirt and sells those pictures, or if that person has a jersey and just has their name, they didn't do anything, say the school did it, is that considered employment? So, we generally know that when it comes to employment, certain things are permissible and certain things are not. For instance, if you're working for an employer and you're getting a paycheck, that's definitely employment. But if you have your own stock portfolio, even though you're earning income and it's a personal stock portfolio, you're not doing it as employment, the question becomes, is that employment at all? Is it like the stock portfolio, or, you own a house that you rent, or you sell your furniture and you earn money selling excess furniture when you move? Or is this really like employment? And it can really depend on the specific type of NIL as well. So for instance, the example of the jersey, the foreign national, does almost nothing. There's no services that are being provided. On the other hand, if they pay to give a speech, for instance, or they pay for photo shoots and other promotions, then that becomes less like the portfolio and more like the employment. So we got to try work out, where does NIL fit in all of it, and that's kind of the main issue that we're doing. This compounded with the fact that, as we mentioned, that US students have very limited work authorization. Usually they don't really have work authorization, to work certainly off campus, and if on campus in very specific, limited circumstances, that puts the foreign athlete who's on an F1 visa in a very difficult situation, mainly because US immigration, CBP, etc., ICE have not really commented on what NIL means for these students. Is this considered employment, or is this not considered employment, and what terms? Would it be considered employment and not considered employment? So you're left without any guidance, and as far as I've heard, there's nothing in the works. It's kind of, fitting a square peg into a round hole, trying to work with what we have to work out whether this is employment. And I think there's certainly lots of angles and a lot of bases to rely on the fact that this is not considered work authorization, that's for sure. But I think you have to have really broad shoulders in order to say that with any sense of definity. I think to have students just collecting paychecks, etc., for this type of work without immigration opining on this officially, I think is potentially dangerous. So there are different options. Some will actually have, if it's like a promotion or something like that, they will have the person do the shoot in Canada, then the services were done abroad. That's one thing I've heard. Others will try to get the student onto a P1 visa with work authorizations. That's, questionable whether it's part of the competition or not, whether it's incidental. So that's another thing that has to be fleshed out. So right now, that's a kind of where we are with the NIL and international students. So I think there are definitely bases to be lenient, but they are, certainly recommended at this point just to be very careful when, applying it in practice.
Thanks, Cliff. And on that, we do have a question. Someone has said, does a scholarship stand in place of contract for college athletes? So I think you touched on that, right? It's kind of questionable and things like that, but whether the scholarship would be in place of a contract. I think in that situation, I may go under like a summary of agreements here.
Yeah. I mean, the importance of the contract is really, I think, to show what the person's going to do in the United States. If there's no payment, then, a letter from the school saying this person will be competing for this team, for the school, for the next 3 years while they're in school. No payment is given, but will receive a scholarship. I think that should be sufficient.
Yeah.
Okay. Any other questions? Okay. So then to sum up, there's a lot of information and it's quite a in detailed area of the law. So, be careful when applying it. Our email addresses are up on the slides. Feel free to reach out to either Josune or myself. We're happy to answer any questions that you may have relating to this webinar. And we're looking forward to your success in the sports athletes visa arena.
Thank y'all.